5 seconds to go. Start. Reiterating the same principle, this court in Ravi versus State has again reaffirmed the aforesaid position by holding as follows. Certain facts are not in dispute. The test identification parade was held after 10 days. It is also not in dispute that the photographs of the accused were taken at the police station. The investigation officer allowed them to be published. Photographs of the appellant and the said Uday Kumar were not only published, according to the prosecution witnesses, they were shown to the accused in the aforementioned crime. Some of them admittedly were aware of the said publication. The purported test identification parade, which was held 10 days thereafter, in our opinion, loses all significance in the aforementioned fact situation. In a case of this nature, it was incumbent upon the prosecution to arrange a test identification parade. Such test identification parade was required to be held as early as possible so as to exclude the possibility of the accused being identified either at the police station or at some other place by the witnesses concerned or with reference to the photographs published in the newspaper. A conviction should not be based on a vague identification. Having considered the evidence of crucial eyewitnesses and the material indicating the conduct of the TIP, we are of the opinion that the witnesses had the opportunity of seeing the accused before the conduct of the TIP. Not only have the witnesses deposed that they had seen the suspects before the TIP, even accused number 2 at the end of the first TIP had raised a grievance that the suspects were all photographed, videographed, and were shown to the witnesses from the cabin of the IO PW84. At the end of the second TIP, he had also stated that when accused numbers 1 to 19 were taken to court for the purpose of remand and the presence of all the witnesses was arranged in the court by the police. In fact, all the accused collectively stated that they were wearing the very same dress straight from their arrest till the date of the TIP to indicate that the TIP did not serve its purpose. We find no reason to disbelieve the truthfulness of the statement of the accused because they had raised this contention right from the beginning and have maintained it all along. In view of the above, we are of the opinion that there existed no useful purpose behind conducting the TIP. The TIP was a mere formality and no value could be attached to it, as the only evidence for convicting the appellants is the evidence of the eyewitnesses in the TIP, and when the TIP is vitiated, the conviction cannot be upheld. We will now examine the other lapses while conducting the TIPs. Undue delay in conducting a TIP has a serious bearing on the credibility of the identification process. Though there is no fixed timeline within which the TIP must be conducted, and the consequence of the delay would depend upon the facts and circumstances of the case, it is imperative to hold the TIP at the earliest. The possibility of the TIP witnesses seeing the accused is sufficient to cast doubt about their credibility. The following decisions of this court on the consequence of delay in conducting TIP have emphasized that the possibility of witnesses seeing the accused by itself can be a decisive factor for rejecting the TIP. In Suresh Chandra Bahari versus State of Bihar, it was held that it is a matter of great importance both for the investigating agency and for the accused, and a fortiori for the proper administration of justice, that such identification is held without avoidable and unreasonable delay after the arrest of the accused, and that all the necessary precautions and safeguards were effectively taken so that the investigation proceeds on correct lines for punishing the real culprit. It is in adopting this course alone that justice and fair play can be assured both to the accused as well as to the prosecution. But the position may be different when the accused or a culprit who stands trial had been seen not once but for quite a number of times at different point of time and places, which fact may do away with the necessity of a TIP. This court set aside the conviction imposed on the appellant therein on the ground that no conviction can be based by solely relying on the identification made in a TIP, while holding that a 14-day delay by itself in conducting the TIP may not cause prejudice to the accused. It observed that there is a high chance of accused being seen by the identifying witnesses outside the jail premises. In Subhas and Shiv Shankar versus State of UP, this court acquired an accused on the ground that the TIP was held 3 weeks after the arrest was made. This court suspected that the delay in holding the TIP could have enabled the identifying witnesses to see the accused therein in the police lockup or in the jail premises. Stop.